This is file number 241081 SM. People versus Travis John Andrews. Is that you, sir?
Yes, sir.
Mr. Andrews, you're here with your lawyer, Mr. John Bush. Also present is your probation officer, Matthew Huff. This is set for a probation violation hearing. Have we resolved the case?
He is going to be making admission to one of the counts today.
All right, very good. The prosecutor isn't here if we had to actually conduct a hearing, but it appears he's going to accept responsibility. This is an interesting and difficult case. Mr. Huff and I have discussed this several times during the term of this probation, including yesterday. Let's go back to square one here. Probation violation petition alleges that he violated his probation. He was placed on probation on September 30th of 2024 on a charge of domestic violence. He, as I recall, headbutted his girlfriend out at Long Lake and threw her phone in the lake. He was placed on a domestic violence deferral probation, and it didn't go very well. The allegation is he violated a criminal law. He got charged with a felony drug possession charge in Cass County, and he failed to report. What primarily started it was he failed to report. He was placed on probation, and then we didn't see him. Failed to report October, November, December, and January, and no reports since. Then they learned that he'd been charged with a charge in Cass County and is facing, I'm not sure what the status of that is. They were considering placement at their mental health court. I also ordered that he do the domestic violence treatment program. That's not in the petition. Did he ever do any of the treatment?
No.
All right. So at some point he returned, he'd been AWOL, and then at some point Matt reestablished some contact with him. I did the arraignment on June 11th with Mr. Stickley. We learned that the defendant had been at the VA. We actually did the arraignment from the recovery center at the VA in Battle Creek by Zoom with the defendant. And we set a hearing which resulted in this hearing. The defendant at that time also had charges pending in Cass County. Matt just gave me this report, which is in microscopic print, indicating that the defendant had been in some treatment at the VA. So before we go forward too far, I would note that Angelique Camfield from the prosecutor's office has joined us. Mr. Huff, what's our current status?
Well, I had no contact with Mr. Andrews from the point of the probation violation arraignment, which, as you noted, was on June 11th at the Veterans Treatment Facility until yesterday. So I've had no contact. He indicates a couple of things are going on new, that he was released from treatment approximately 2 weeks ago, end of July, and that he's set to go back to another treatment, post-traumatic stress disorder program, September 17th. Apart from that, I don't have a lot of information, and perhaps Mr. Andrews or his attorney could shed some more light for you.
With the weariness of someone who's seen this rodeo 100 times, the judge recapped the defendant's greatest hits: headbutting his girlfriend, drowning her phone, ghosting probation for months, picking up a fresh felony drug charge, like it was a bad season recap of a show nobody asked to renew. Between decoding microscopic probation reports and juggling VA Zoom arraignments, the judge still managed to point out the obvious. Treatment programs don't work if you treat them like optional field trips.
All right. Mr. Bush, can you tell us what the status of his Cass County charges are?
It's my understanding that they're set for trial on October 24th of 2025. He said Greg Feldman from Edwardsburg is his legal counsel.
So you had a preliminary examination and the matter got bound over?
I believe so.
Or-
Yes,
all
sir.
right. Boy, they get things to trial fast in Cass County. If that actually goes. All right, Mr. Bush, what's our plan for this morning?
Obviously, he's in no position to make any admission regarding the new charges, but for purposes of probation violation, he would admit that he failed to report and contact Mr. Huff.
Sorry about that. I brought my phone in here to scan a driver's license. It's going off. All right, Mr. Andrews, as I told you before, you have a right to have a hearing regarding this violation of probation allegation. And Mr. Bush, your original lawyer, was reappointed. Also, at that hearing would have the matter established at least beyond a preponderance of evidence. Frankly, this isn't going to be very hard to prove that you didn't show up for months and you didn't do the treatment that was ordered. So you also can simply admit that. Is that what you wish to do here this morning?
Yes, Your Honor.
All right. Tell me what happened. I put you on this probation. I had good thoughts of a domestic violence treatment program. We never even got the balloon 1 inch off the ground. What happened?
From there, the person that was involved with this and I split up and I kind of spiraled out of it, mental health crisis. Isolated for months in home.
Out at Long Lake?
Yes, sir.
You still have the house on Walnut Drive?
Yes, sir. I just kind of shut down. I said I was just a serious mental health crisis at the time.
That sounds like it.
Has
Now, the charge in Cass County is methamphetamine,
cocaine, sir.
cocaine, neither of which you need, but
No, not at all. There are a lot of poor decisions and a lot of people that are important to be disappointed.
well,
Tell him how you got to.
so then at some point you got back on the horse. When I saw you in June, you were at a VA treatment facility and I talked about your service in Iraq and other places and PTSD issues and other things that you're dealing with. So when did you go into treatment at the VA?
I went into the inpatient mental health ward first, just kind of get stabilized, and that was 12th of May. I spent a week there. I went home for a week, and then I came
Now
back.
that was after your Cass County arrest?
Yes, sir. I kind of hit rock bottom with that.
Sometimes that's what has to happen. You have to hit rock bottom to start to climb back up. And so then, Matt said, I haven't heard from these people. We got, the PV when you were at the VA, then you got out of the VA. You didn't contact him and then heard from you yesterday.
The judge practically gift-wrapped the defendant's entire downfall like a sarcastic bedtime story, starting with the light details of ghosting probation, skipping court-ordered treatment, and racking up a meth and cocaine felony like it was a grocery list. With surgical precision, he reminded everyone that the domestic violence rehab program never even left the runway before spiraling into a crash landing at Long Lake. He tossed in a little life lesson about hitting rock bottom, but not before casually pointing out that this whole mess wasn't exactly a whodunit, proving failure to report when you disappear for months is about as easy as proving water is wet.
Then in June, June 2nd to 30th, I did a 28-day inpatient recovery program.
So there's two things going on. There's your mental health issues with PTSD and others, and there's addiction issues. What is the recovery from? Cocaine, alcohol?
Cocaine.
Okay. Cocaine had fallen off the map when I was a very young prosecutor. It was heroin in the 80s, early black tar heroin. Then it was cocaine. Then it was crack cocaine, which we thought was terrible, as bad as it got, till methamphetamine showed up. Then cocaine seemed like a distant memory. We also had lots of marijuana cases, but we thought crack cocaine was bad stuff, which it is. Then we get Oxycontin and prescription opioids that they were passing out like M&Ms. And we dealt with thousands of people with opioid problems. And then we get fentanyl, which kills people. So it's been a tragic progression of substance addiction and harmful substances, not all narcotics. Cocaine seems quaint now, but it is very addictive and involves effect of your mental health. All right, so you got a lot going on. You got a case pending, you got counsel in another county, you're connected to the VA, you've got further treatment planned, but this probation was a dud. We didn't really accomplish much of anything, particularly regarding domestic violence treatment. In light of his admission, Mr. Huff, what's your recommendation?
Well, this is a very difficult case to make a recommendation on for a couple of matters that have been highlighted already. First and foremost, I mean, some of what he's going through obviously stems from his service and the post-traumatic stress that he suffers from as a result of it. So I think there's a certain amount of empathy that ought to be extended given the context of his situation. But we also have to consider the fact that there's a victim in this case. And I do wonder if the victim was sitting here in the courtroom, what she would say. What she would say needs to happen in order to get his attention, because obviously this was someone that he had an intimate relationship with, and probably somebody who they both cared about for a while. But the bad stuff that was going on was enough to make a permanent split. I think that this was probably always about mental health and substance abuse. That's probably why the split happened. Maybe I'm wrong, but again, we don't know a whole lot when I don't have communication with a probationer. I'm a little bit concerned, again, there's a gap where I have to fill in the blanks there and wonder what happened from when he was released from treatment. And then he calls me the day before the probation violation hearing.
The judge managed to turn a probation hearing into a crash course on the sordid history of America's drug epidemics, casually time traveling from 80s black tar heroin to the fentanyl crisis, making cocaine sound like some retro collector's item instead of the life-derailing addiction it is. Without raising his voice, he laid out the irony like a pro. The defendant's probation was such a spectacular dud that not even a VA connection, counseling, or further treatment plan could disguise the fact that the domestic violence program never even got off the launch pad.
I am encouraged that he's willing to admit that he's responsible for these actions and that he wants to, I guess, curb this sort of behavior from his life. But at the same time, there needs to be some sort of ramification for his actions. I don't want to deprive him of going to the post-traumatic stress disorder program at VA in Battle Creek. So first and foremost, I would say if the judges or if the court's inclined to impose a jail sanction, that it'd be less than the amount of days that it would take in order for him to go to that program, because I don't want to see the court, obviously anything that happens, he's earned. However, I don't want to see us get back in the way and have him go down again. I think I use the analogy, I don't like to hammer people who are back on the upswing. But this is a very difficult situation. I don't think his history is conducive with the probation. I don't think the probation should be continued. There's a non-public status. attached with this, I believe, as well. I don't think that you can go out and get a new charge, abscond, and have several positive tests, several missed tests, and still have a probation go through successfully. I just don't believe that that is the spirit of what probation is designed for. So I think some jail is appropriate. I don't think a lot of jail is necessary to get Mr. Andrews' attention. I think we have his attention right now, but I would give my input there. And then I also wanted to make one note too about the request for release of information that I provided the court with. I showed Mr. Andrews' counsel the exact same document ahead of time. A little bit concerned because it's kind of like a half authorized information release. It shows that they can give us discharge dates and acceptance dates, but they can't talk to us about what sort of treatment they're doing or any intimate details. I don't need to know ever with any of my clients what they're talking about, the topics. But the second box that's checked on there just basically says, like, unless it has to do with drug abuse counseling treatment, I don't want any information given to the courts. And so I'm sure, if I talk to him, he'd probably be like, oh yeah, I want to check that box, or I'll sign something different. But that's why I provided the court with that. I just wanted to make that clear.
All right, we'll hear from the prosecutor and then we'll hear from Mr. Bush and the defendant. Ms. Camfield, do you have any input on this?
Your Honor, mental health concerns are always difficult for the court and probation agents to deal with when they may be an explanation for assaultive behavior, but certainly not an excuse for it. In this particular instance, as I'm reading the report, it indicates that she may have had a broken nose from being headbutted in the face by this defendant. Children were going to be coming over later. He just failed to do anything that he was supposed to do. He's aware of that. He's indicated to the court why that occurred, and did subsequently get himself into treatment programs which were appropriate. But again, we have him having committed an offense and being put on probation to rehabilitate from it. And while he is getting mental health treatment with the VA, it most certainly is not the domestic violence therapeutic program that this court ordered. And I'm sure that that particular instance may not even be addressed to the extent that it would have had he complied with his probation here. Whether or not they're still together and whether or not that was a toxic relationship is not as important as how do we rehabilitate him not to be violent with another partner in the future, and also give a consequence for what he did to his previous partner. It was a pretty serious assault.
The judge didn't have to raise his voice or pound the gavel. He let the facts roast the defendant all on their own. Months of vanishing, blowing off court-ordered domestic violence treatment, racking up new charges, and only resurfacing when a hearing was on the calendar. This wasn't some close call in the spirit of probation. It was a crash and burn from day one. And while the VA treatment might help with PTSD, the judge made it clear it's no substitute for actually addressing the assault that broke a woman's nose and left children about to walk into that mess.
He's failed to comply with this court's order. So I do agree with Mr. Huff that jail is appropriate. Under circumstances of this, if there weren't a mental health component and he hadn't availed himself of the VA services over this past summer, I would have recommended the maximum time in jail for the offense, in addition to the revocation of the deferral program and the entry of the conviction. At this point, I'll leave the jail to the court's discretion, understanding that he's got a program waiting for him, but also knowing that he needs to have a severe consequence for what he did to this victim, as well as just ignoring this court's orders for the duration that he did.
All right, Mr. Bush.
May I do this seated, Your Honor?
Yes.
Mr. Andrews shares with me that he served in the Air Force from 2003 to 2012. He was medically retired with a 90% disability. Hence, he's not a candidate to go into the employment competitive employment world. He shares with me that since his release from the VA substance abuse program, he's been doing weekly online counseling with the VA counselor. It's also been brought up by Mr. Huff that the plan is for him in mid-September to go to the PTSD program. That's a 5-week residential program. Those are all matters that he wants to complete. He shared with me today that he had no intention to restrict Mr. Huff's office or the court on his release to the VA. And if for whatever reason the program is continued or the probation is continued, he will willingly sign a new release that gives Mr. Huff free access to his programming. But with all that in mind, it doesn't look like the probation is going to be successful. The revocation is certainly probably the likely result. There has to be a degree of punishment. I don't think anything greater than at least 6 or 7 days needs to be done based upon the services that he has endeavored since the time. Thank you.
Mr. Andrews, anything you'd like to tell me?
I don't ever like to use my service as an excuse for bad behavior. I got injured doing my job. Never really fell apart until recently.
How are you doing with cocaine?
Got 104 days today.
All right. There was a little unspoken piece here. It was acknowledged that he threw the complainant's phone in the lake. And I remember she had a victim impact statement, and I was concerned about restitution. She wasn't here. She asked for a bunch of other stuff: AirPods, swimsuit, hand-blown glass piece, emergency room CAT scan, canopy tent, air mattress, missed work. So I reserved on restitution, intending at some point during the course of probation to go back and visit the restitution issues. And certainly the phone was pretty straightforward. He threw a phone in the lake. But all the rest of this stuff I wasn't clear about. And as I recall, she wasn't present at the sentence. So I reserved on the restitution. You're not Sarah, are you? Okay. You're here on the Detler case? All right.
The judge managed to slice through all the soft excuses and sympathetic framing with the precision of a scalpel. While everyone else tiptoed around the complexities of PTSD, treatment schedules, and VA programs, he brought the focus back to the plain truth. This was a court order ignored for months, a serious assault that left a victim with a broken nose, and even a phone hurled into a lake for good measure, like some twisted bonus crime. Without raising his tone, he dismantled the idea that military service is a free pass for bad behavior, treating it as context, not absolution.
So I regret we never visited that. So in addition to everything else you didn't do, you never paid her 1 cent for, she had a medical bill, she had to replace her phone.
He shares with me he did pay for the phone.
You did
I
pay
don't
for the
think
phone?
Paid for the phone. I had no idea of the other items at all. And she has all those. Everything that you just listed off.
Well, again, I didn't have enough information to deal with it, so I reserved on it. Here's what she said at that time in her victim statement a year ago in June. In your opinion, what is the appropriate sentence? Anger management in therapy, in big bold letters, all capitalized. We never got there. Therapy, maybe, no anger management. Whatever consequences the judge deems appropriate. He seems to think he only has to answer to himself. he could use a reminder that he has consequences, cannot do whatever he wants, whenever he wants. So we tried this probation, which was a flop. But I'm hopeful. I'm gonna revoke the probation and loss of deferral status. The man, you can't use or possess a firearm for the next 8 years.
So,
Anyway. On order 2 days jail starting right now. And revoke your probation. You've got some treatment coming up. You've got charges pending in Cass County. They're considering mental health treatment court, which I think is a good program. Judge Renfro and I think Judge Beeler run that. Anyway, you're going to jail. I'm off your back. I'm waiving your fines and costs. I'm revoking your probation, loss of deferral status. But as your ex says, you cannot do whatever you want, whenever you want. You've been discharged from the service for 14 years. Cocaine got in there and mixed things up even more. But when you get out of jail, I'm off your back. I wish you the best of luck in your Cass County endeavors. I'm not ordering any further restitution because I never sorted it out. Defendant says the phone has been paid for and the other property is returned. All right, you're good to go, sir.
my ride this other.
Luke? Or Luke, Matt? Any sign of Luke Knopfinger out there?
Yeah.
Nicole, he's out there? All right, thanks. Thank you, Mr. Bush.
The judge wrapped this case like a master of understated sarcasm, delivering a sentence that was equal parts consequence and reality check. While the defense tried to patch together a story about phones paid for and mystery items magically returned, the judge coolly reminded everyone that this wasn't about nitpicking over AirPods or canopy tents. It was about a year of ignored orders, zero therapy, and a probation performance that could only be described as a spectacular flop. With surgical precision, he cut through the self-pity, revoked probation, and tossed in jail time, not as vengeance, but as a crisp, no-nonsense reminder that you cannot do whatever you want, whenever you want.